AI does not meet the requirement of being a legal person. This raises an important question about whether AI can be recognized as a creator in any jurisdiction. A significant issue to consider is the question of liability in cases where an AI system commits an infringement. An even bigger scenario is moral rights and AI authorship. AI systems are rarely confined to a single jurisdiction. They are developed, trained, and used across borders. Artificial intelligence presents many challenges for governments, companies, individual creators, researchers, and other stakeholders. In a largely global world connected by technology, the need of the hour is to have a global IPR regime that can deal with the challenges posed by artificial intelligence. The advent of artificial intelligence, or AI as we know it, is one of the biggest phenomena of the fourth industrial revolution, that's the technology revolution. A report projects that by 2030, AI will contribute $15.7 trillion to the global economy, more than the current output of China and India combined. The application of artificial intelligence is so wide that now it would be unaffordable for any country not to have a strict intellectual property regime in place. Today, AI, coupled with machine learning or ML, is reshaping the global business landscape. Hence, it becomes imperative on the part of governments to recognize the fact that AI is there to stay and it is destined to bring a new set of challenges to the global intellectual property regime. Now, what are the challenges that AI poses to the global IPR regime? Countries across the world are struggling to regulate intellectual property amidst the rapid growth of AI. This situation raises important questions to the global IPR framework regarding the production of AI-generated content and the ownership of the rights associated with such work. Current intellectual property laws grant exclusive rights to creators, allowing them to prevent unauthorized use of their works and in turn encouraging innovation through a potential financial and reputational gain. Now, this system may not apply to AI at all, since AI itself does not receive financial or reputational rewards. Moreover, existing intellectual property regulations do not protect creations that lack human involvement. As early as 2017, an artificial intelligence system, DABIS, was cited as the inventor in patent applications in the United Kingdom, United States of America, and in Europe. All these applications were rejected because AI does not meet the requirement of being a legal person. This raises an important question about whether AI can be recognized as a creator in any jurisdiction. In India, the Patents Act of 1970 and the Designs Act of 2000 do not allow patents for inventions created by software or artificial intelligence systems. The Copyright Act in India comes close to offering protection, as Section 2D6 recognizes the person who initiates the creation of a computer-generated work as its author. The next issue to consider is the ownership of works created by AI systems. The protections offered under the global intellectual property rights regime enable creators and inventors to control the use of their creations and safeguard against infringement. However, this does not apply to AI systems which lack legal status necessary to own intellectual property rights. The question of who holds the IP rights for an AI-generated creation remains ambiguous in many jurisdictions. One potential solution is for AI models to assign IPR rights to individuals who command the systems, granting such individuals ownership on the resulting work or the innovation that comes about from the AI system. For instance, ChatGPT in its terms of use grants intellectual property rights to users who issue the commands. Similarly, the AI company Claude also associates intellectual property rights to individuals providing directives as stipulated in their consumer terms. Another concern is the vast amounts of data used by AI systems and machine learning algorithms. These systems often require extensive data sets, including personal information, to enhance their performance. Therefore, it is essential for companies to comply with data protection laws when designing and implementing operating AI systems. This includes establishing a lawful basis for data processing, adhering to relevant regulations, and obtaining a clear, informed, and specific consent from the individuals. A significant issue to consider is the question of liability in cases where an AI system commits an infringement. Since AI is not recognized as a legal person under extant laws, holding it accountable for such infringements poses considerable legal challenges. Consequently, the responsibility for any legal repercussion falls on the various stakeholders involved in the development, deployment, and use of the AI system. How can AI help build a robust global IPR regime is a question often asked. Artificial intelligence presents many challenges for governments, companies, individual creators, researchers, and other stakeholders. In a largely global world connected by technology, the need of the hour is to have a global IPR regime that can deal with the challenges posed by artificial intelligence. Several key aspects are often missing from the discussions of AI and global intellectual property rights, creating an incomplete picture of the challenges and opportunities that are offered. The international harmonization and jurisdictional issues are another major omission. There is a lack of global harmonization in artificial intelligence related intellectual property law. AI systems are rarely confined to a single jurisdiction. They are developed, trained, and used across borders. This creates a significant jurisdictional conflict. Which country's law will govern IP rights associated with an AI-generated work is a million-dollar question. The absence of international agreements or consistent legal standards leads to uncertainty and makes cross-border enforcement of IP rights extremely difficult. Many discussions focus on AI's impact on copyright and patents, but neglect the other forms of intellectual property such as trademarks, trade secrets, and designs. Let's not forget, artificial intelligence can generate novel designs, create unique brand identities, and potentially infringe the existing ones, and even contribute to the development of new trade secrets. These issues are yet to take the center stage in a discourse. Data is the lifeblood of artificial intelligence. The data sets used to train AI models often contain copyrighted materials, patented information, or personally identifiable information. The legal status of these data sets and the rights associated with them are frequently overlooked. Questions of data ownership, licensing, and the possible use of copyrighted material for AI training needs a thorough examination, along with the consideration for data privacy regulations. An even bigger scenario is moral rights and AI authorship. Beyond the economic, you have the moral rights, which are crucial to law enforcement and institutional creators. But who holds these rights when the creator is artificial intelligence? These questions require a deeper philosophical and legal inquiry into the concept of authorship in the age of artificial intelligence. Discussions frequently focus on the legal challenges, neglecting the practical difficulties of enforcement. Tracking and proving infringement in a digital realm is challenging, especially with AI-generated content, and that can be easily modified, copied, or distributed globally. Exploring the role of technology in both infringing and enforcing intellectual property rights, including the potential for AI to assist in the detection, is crucial. But this is not to say that these challenges eclipse the opportunities that are offered by artificial intelligence. In copyright enforcement, AI tools automate anti-piracy systems, improving the effectiveness of identifying infringing content. Recently, YouTube's Content ID is a successful example that detects violations and reduces human workload, although effectiveness typically relies on the accurate training and the data sets that are involved. For detecting design infringements, advanced image recognition can help identify potential violations. The UK's Anti-Copying in Designs initiative maintains a data bank of over 300,000 designs, including unregistered ones, which can train AI systems to recognize infringing designs. In trademark enforcement too, AI tools can analyze large data sets efficiently, reducing the reliance on extensive human resources. The European Union Intellectual Property Office provides tools for tracking, risk analysis, and identifying suspicious domain names and registrations. Regarding patent violations, AI can revolutionize the detection processes by examining vast databases of patent information to identify infringements. This capability can expedite resolution and significantly lower litigation costs. When equipped with a robust training data set, AI has the potential to detect IPR infringements at scale. AI-powered IP analytics tools can uncover trends in violations, enhance enforcement, improve tracking, and lower costs associated with global IP regimes by minimizing human intervention. AI speed and accuracy makes it an inevitable tool for identifying infringing intellectual property content promptly. Now, how are governments addressing the challenges posed by AI to the global IPR regime? Amid global uncertainties, India stands out as one of the few countries to grant copyright protection to creations by AI systems. The AI-based painting app Raghav produced a painting titled Suryast, leading to 2 copyright applications. The first application listed Raghav as the sole author and was rejected. In contrast, the second application named both the app owner and Raghav as co-authors, successfully receiving copyright protection in November 2020. However, the Indian government has adopted a somewhat lackadaisical approach towards implementation of AI innovations on the country's IPR regime. Officials have stated that existing laws are sufficient to address IPR issues, which I seriously doubt. In the US, the Copyright Office denied registration for artworks created using a text-to-image AI tool, despite the creator claiming that significant inputs through 624 text prompts were issued during the image adjustment process. Additionally, the Federal Circuit ruled in August 2022 that under the US Patent Act, an application must refer to a human being as the inventor. This decision underscores the legislative gaps and effectively closes the door on patent protection for inventions with AI as the sole inventor. In the United Kingdom, copyright protection for computer-generated work is somewhat clearer. The Copyright Designs and the Patent Act, specifically sections 9(3) in conjunction with 178, offers copyright protection for these works. Therefore, the challenges posed by AI are multifaceted. No single solution will suffice. Addressing these challenges requires a comprehensive strategy of encompassing legal reform, technological advancements, international cooperation, and ethical considerations. A balanced approach is crucial, one that promotes innovation by clarifying intellectual property rights associated with artificial intelligence generated content, whilst simultaneously protecting creators and preventing the misuse of AI for malicious purposes. Continued research, dialogue, and collaboration among legal experts, AI developer, policymakers, and other stakeholders are essential to navigating this complex and dynamic landscape. The rapid pace of AI development necessitates a flexible and iterative approach to the legal framework, ensuring that they remain adaptable to the technological advancements and societal needs. Only through ongoing engagement and a commitment to responsible innovation can we ensure a future where both intellectual property rights and transformative potential of AI are both secured.